Hi everybody, Jack Meligan with you again from the Plaintiff's MSA and Lien Solution. Today's topic, trial attorneys who have been sued over Medicare issues. So in my conversations with attorneys all over the country, whether they're calling in the office or where I'm at a speaking engagement at a conference, the subject always comes up about MSAs and Medicare conditional payments. And I seem to hear the same refrain along the way. Attorneys know they've got to settle the Medicare conditional payments and resolve that because, well, mainly defendants are requiring it before they'll hand over the settlement check. But when it comes to dealing with future medical, what I hear from attorneys is, you know, I don't think I have to deal with that. I'm told I don't have to deal with it. It's not legally required. Unless attorneys are being sued by Medicare, I'm not going to deal with it. So that's the topic here today. Attorneys who have been sued by Medicare and or been sued over Medicare issues is probably a more correct way to say that. This particular area is fraught with peril. We've got and located several dozen attorneys now that have been sued over Medicare issues, whether it was Medicare conditional payments or a Medicare Advantage organization claiming that their lien wasn't resolved properly or correctly or even resolved at all. So how does all this happen and how do we deal with it? Well, first off, what I want to say about this is the time has come. Attorneys are being sued over Medicare issues. I'm going to talk about 5 of them here real quick. And all of this is, essentially is solved by a company like ours because I created this company to deal with these very issues, to take it off your desk, and to make sure that your client gets the absolute best result in their settlement when it comes to dealing with Medicare, MSA issues, and all of the other lien resolution issues, which we handle all of that. We got all these services, all right? But here's the deal with attorneys being sued by Medicare. This all really goes back, I think, I want to talk to you first about an attorney in Gulf Breeze, Florida that had a run-in essentially with Medicare, got some bad advice. The attorney's name is John Merton. He's from Gulf Breeze, Florida. And back in 2003 or so, he contacted CMS and said, hey, do the Medicare secondary payer rules apply to Jones Act cases, FELA cases? And the answer he got back in writing was no. Okay, so he goes on to settle his client's Jones Act case for a handsome sum, around $5.5 million. And just before the settlement, he contacted CMS again just to make sure nothing had changed. And you can read his letter, it's out there, or you can call us and we'll give you a copy of it. But he writes him a letter and says, hey, has anything changed? And CMS writes back and says, no, nothing's changed. Nothing's changed since the last time we gave you our opinion on this. So he settles his client's case. Lo and behold, 60 days later, client gets a letter from CMS, and now John and his client are being told that unless his client can prove that he spent $5.5 million on future Medicare allowable expenses related to the injuries that he suffered in the incident that spawned the lawsuit, the Jones Act settlement, they're not going to cover him for anything related to the accident, of course. So what a shock. He has it in writing, but now the government's going crawfishing on him, as they say. So the reason this is instructive, I think, is that if you're looking to call CMS to get advice on these issues, I'd be careful. John Merton is just the first. There have been others who have asked for clarifications and gotten one answer, and then 60, 90, a year later down the road, they're told something completely different. Now, for some attorneys who have been sued over Medicare issues, probably the first and most famous is the Paris Blank law firm in Richmond, Virginia. Keith Marcus is the partner there that was involved in the case I'm going to mention. But Paris Blank negotiated a settlement for their client, a late 60-year-old gentleman who was on Social Security retirement, Medicare, bad car accident. And as is required, Paris Blank contacted CMS and asked for a Medicare conditional payments report. Came back 0. They asked to verify that, came back 0 again. They scratched their head and said, okay, hey client, what happened here? Were you on a Medicare Advantage? Are you on a Medicare Advantage plan? And because of the way I understand that they phrased the question, the client answered honestly and correctly at the time that he was asked the question. He wasn't on a Medicare Advantage plan, but the question should have been, were you ever on one, and especially at the time of the accident, because that's what happened. Humana had provided a Medicare Advantage program for that client 3 years prior, and that's where all the bills went. So after settlement, Humana contacts Paris Blank, this is 9 months later, and says, your client owes us $191,000 for medical bills that we took care of from that accident. And the settlement itself was only $475,000. It had already long been distributed. And Paris Blank pushed back, fought back, said, no, we got a letter from Medicare, CMS, we didn't know anything, this is all handled. Humana said, no, you owe us this money. Paris Blank said, no, we don't. And then Humana dropped the hammer and said, okay, by your denial, we're now going to sue you for double damages. That case has been settled confidentially. I understand there was quite a bit of the additional double damages that had to be paid. But the interesting thing that we found out from interviewing the firm was that they contacted their professional liability company to put them on notice, and the professional liability company notified Paris Blank that if they made a mistake on the $191,000 of missed lien, essentially, that they were covered for that, but the double damages, the double part, the extra 191, is essentially a punitive damage, and they were told your policy doesn't cover that. That's on you. So I understand they had to pay a major chunk of that. Next case, Floyd Falcon Jr. in Baton Rouge, Louisiana, representing one of his state trooper clients, missed a Medicare conditional payments lien with Humana again, and ended up getting sued by Humana. Then we have down in Texas a whole group of attorneys handling mesothelioma cases. These attorneys, Brett Kuhn, Riad Morgan and Quinn, the Bogdan Law Firm, Foster and Sear, Hissey Kientz, and Schrader and Associates. A whole raft of these cases. And Medicare CMS came in and said, you didn't handle the conditional payments, and we want this money. This litigation is ongoing. Then here finally, we've got Philadelphia attorney Jeffrey Rosenbaum, and poor Jeff missed handling the conditional payments on 9 of his client cases to the tune of about $28,000, and he ends up with the Department of Justice coming after him, and he had to sign a settlement agreement to pay the $28,000. And the agreement also said he can't deduct the $28,000 as a business expense. He can't deduct the attorney fees or other expenses that he had to incur to deal with the situation, so it's a true fine. And then he's also had to agree that he's going to train one of his staff and certify to the government he's got trained staff on hand that knows how to handle conditional payments in a timely manner, and he's got to be able to verify that every 6 months. He's got to have a meeting with his staff every 6 months to verify that there aren't any snags or holdups on any of the cases in the office where something's being slid off or pushed under the table. Essentially, what happened to Jeffrey Rosenbaum is he now has the Department of Justice in his law practice, and essentially they've got the right to come in and audit that he's complying with this settlement agreement. And they also warned him that if he ever made another mistake again in dealing with a conditional payments resolution, that he would be subject to the Federal False Claims Act and treble damages. So Paris Blank was subject to double damages. Some of these other attorneys that I mentioned are subject to double damages, but down here with Jeffrey Rosenbaum in Philadelphia, we've got a guy now that's subject to treble damages in the future for violation of Federal False Claims Act. So this area is getting more and more complex. It's more and more serious. The United States government is broke to the tune of $22 trillion on the current budget. We just heard from the heads of the trust fund at the Social Security Trust Fund and the Medicare Trust Fund earlier this fall that those two entities, those two trust funds are running out of money, and that Medicare will be out of money in 2026, I believe it is, and Social Security itself in the 2030s. The government's got to come after money, and they think that this is a stream that they can tap into where they get conditional payments money back, and then they also deal with making sure that these clients of ours don't send bills to Medicare and CMS in the future for treatments for the conditions and injuries that were the subject of these settlements that you all are securing until that claimant has spent some of the money out of the settlement that presumably was allocated for future medical. And that's where this all kind of comes full circle, because there's a lot of discussion in the country right now that you can settle the conditional payments, the past medical, but what about the future medical? And what happens when Medicare has been paying a client's future medical bills related to the incident or the accident that you just got them a settlement for, but now years down the road, those bills have been going into CMS, and CMS discovers that they've been paying and they shouldn't have been, and they come back and they want their money back. They've got a right to it. The discussion out there is that the right flows from the fact that this is essentially a new conditional payment that's been created, and they've got a right to get it all back, and they got a right to get it back from the plaintiff and anybody that took money out of that settlement. And so that's where this whole question of an MSA comes in, because if you want to avoid litigation over Medicare conditional payments, if you want to avoid getting sued by Medicare over Medicare issues, if you want to avoid being one of the attorneys that's had this kind of disruption in their life and their practice, then you've got to address the future medical conditions and how those bills will be paid, or whether there is any Medicare liability at all for your client, because there may not be. I've lectured and produced videos on the 3 ways to avoid Medicare and an MSA, and these 3 ways, by the way, do not jeopardize your client's future Medicare benefits, and they don't visit additional liability, professional liability on you as the trial attorney. And if we can't help your client avoid this, and not everybody qualifies for that, but quite a few do, then we minimize the MSA allocation to the rock bottom dollar that is reasonable and defensible, so that your client has just a very, hopefully, minimal amount that has to be set aside for future Medicare allowable bills related to their incident. And if you want, we can go so far as to get all of this wrapped with a legal opinion from one of the top Medicare lawyers in the country, so that if anything ever happens, if your client is ever accosted by CMS or Medicare, it's not you that has to defend the client, it's another law firm that specializes in this. So that's today's video on lawyers that have been sued over Medicare issues, and I'll have more to come in the future. Stay tuned. This has been Jack Meligan for the Plaintiff's MSA and Lien Solution. Back later.